Many Florida property owners ask a very common question: can I simply add my child to the deed to avoid probate? It makes sense. You want to make things easier for your family. Bypassing the delays, the costs, and the general headache of the probate court is a logical goal. But a deed is a binding legal transfer. It is a powerful planning tool, and downloading a blank form off the internet to swap names can trigger immediate legal consequences. Focusing entirely on the probate process often obscures severe hidden risks. How you hold title directly impacts who actually controls the property, how the IRS evaluates it, and whether it remains protected under Florida law. When you treat a complex property transfer as a quick administrative shortcut, you risk creating legal and financial problems that are far more difficult to solve than the probate process you are trying to avoid. The moment you add a name to a deed, you are signing over a literal ownership share of the property today. Because of that new shared ownership, you lose the ability to make unilateral decisions. If you decide to sell, to refinance the property, or take out a mortgage, you will need that child's explicit signature to move forward. You also tie your property to their personal financial life. If that child goes through a messy divorce, faces a lawsuit, or files for bankruptcy, your real estate may suddenly be exposed to their creditors. Then there are the hidden tax risks. Moving property out of your sole name during your lifetime alters how the IRS calculates the value of that asset and may trigger specific gift tax reporting requirements. This chart compares a low purchase price to a high current market value. Property passing at death receives a step up in basis to current rates. Gifting property during life destroys this benefit. Without it, that gap remains taxable, creating a massive, avoidable capital gains bill. A simple addition to the deed effectively mortgages the current safety of your home against your child's future financial mistakes, while potentially saddling them with a heavier tax burden. Florida does offer an alternative tool designed to solve the problem of losing control. It is called an enhanced life estate deed, commonly known as a ladybird deed. A ladybird deed allows you to retain total, unilateral control over the property until the exact moment of death, activating the transfer. But if you name 3 children directly, that single asset instantly fractures into separate, isolated blocks of co-ownership at the end. This creates a prime environment for gridlock. One child wants to sell, another wants to live rent-free, and a third stops returning calls. Because they all co-own the property, they all have to agree. When they don't, the ultimate result is often a partition action, a lengthy legal dispute where family members sue each other to force a sale. To prevent multiple beneficiaries from fighting over a single asset, you can use a revocable living trust. Instead of naming individuals, the trust acts as a central decision maker, allowing a single successor trustee to manage, sell, and distribute proceeds smoothly. However, a trust only works if it actually controls the asset. You have to undergo trust funding, which means the deed must be properly transferred into the trust or carefully coordinated with it. Bypassing the probate court accomplishes nothing if the resulting legal structure pits your children against each other in civil court. If the property is your primary residence, it falls under Florida's strict homestead laws. These rules provide significant protection against creditors, but they also place rigid legal restrictions on how you can transfer the title. For instance, if you have a spouse or a minor child, Florida law may actually prevent you from deeding your home to anyone else, even if your spouse's name isn't on the current deed. A transfer that ignores these family rights can be ruled entirely void, creating an immediate title crisis for your heirs. True deed planning is about anticipating real-life risk. It requires looking at the property, the tax implications, and your family dynamics to select the right legal tool for your exact situation. Successful planning requires looking past the immediate goal of avoiding court to determine exactly who will have the legal authority to handle the property after death. Before you sign, record, or rely on any deed, sit down with a qualified attorney and a tax professional. Evaluate your specific facts to ensure the plan does exactly what you intend. Avoiding probate is a valid starting point. But a well-planned deed secures the full value of your property and preserves your family's lasting harmony.